Scarlett Johnson on deck.
All right. Chairman Kitchens, Vice Chairman Gobin, and members of the Assembly Committee on Education, thank you for providing me with the opportunity to testify in favor of Assembly Bill 5. My name is Lauren Greuel. I am Associate Counsel at the Wisconsin Institute for Law and Liberty. I'm here today to discuss why passing curriculum transparency legislation is beneficial to student outcomes and necessary to build collaboration and trust between schools and their communities. Research has demonstrated again and again that parental involvement is a key factor that influences the educational outcomes of their students. As such, fostering collaboration, transparency, and trust between parents and their children's school is one of the most important things that Wisconsin school districts can do. This fall, and as we've belabored at length about today, a new wave of concern over how students are doing in Wisconsin schools began because of the Department of Public Instruction's decision to redefine student achievement standards, ultimately leaving communities in the dark about how their schools are performing and how proficient their students are. Now more than ever, parents want to know how their student is doing in school, what is being taught in the classroom. However, we continually receive complaints at the Wisconsin Institute for Law and Liberty that when parents request curriculum, instructional materials, and educational records, they are often faced with hurdles from the school districts. Oftentimes, districts want to do the right thing and give parents access to the records they're requesting, but they do not have an efficient enough process to handle requests, or the request process is confusing for parents and they don't know how to contact their school, who to contact, or how to phrase their request. However, we also see that school districts will hide behind the nebulous language of the open records law in Wisconsin, which states that a request shall be, quote, filled as soon as practicable and without delay, leaving parents waiting for months and months, or even worse, the school district will quote them thousands of dollars for a small set of records. For example, Will was contacted by a parent who requested records from the Yorkville School District on November 3rd, 2023, and the district took until October 23rd, 2024 to produce the records, a whopping 11 months later and after their student had graduated into the next grade. In another instance, a parent requested records from the Amory School District on March 1st, 2024, and still has yet to receive any of the records that she requested. Even lawyers at will, myself included, have trouble getting districts to comply with our requests in a fair and timely manner. In two recent examples, the Wisconsin Institute for Law and Liberty was quoted $11,000 after requesting records in Sun Prairie, and $2,000 after requesting records in Marinette. A common argument against more transparency is that we do already have federal and state laws on access to student records. While this bill has a similar purpose to federal law and our Wisconsin open records law, the bill provides much needed clarity and guidance to accomplish these important policy goals. Under federal law, specifically the Protection of Pupil Rights Amendment, or the PPRA, parents have a right to access instructional materials used in the classroom on the education of their children. So as we just heard, DPI made claims that it would be expansive or aggressive to allow parents all the instructional materials that are required. However, it's already federal law that be provided to parents at no cost. Under Wisconsin open records law, quote, all persons are entitled to the greatest possible information regarding the affairs of government and the official acts of those officers and employees who represent them. And as such, authorities must either fill the request or notify the requester of the denial of the request, as I've already quoted, as soon as practicable and without delay. These quotes, within a reasonable period of time or as soon as practicable and without delay, should mean as soon as possible, but as I've already described, parents and community members are often left wondering about their requests for months and months after they've been made. This bill, on the other hand, specifically says that the school board shall comply with a written request under this paragraph by no later than 14 days after the date on which the school board receives the written request. So this solves the problem of the language. It provides clarification and it provides structure. Another common criticism of additional transparency efforts is that it will cause additional and unnecessary burdens on school districts. This is not true for several reasons. One, as I've already stated, schools are already required by state and federal law to provide these materials, curriculum and instructional materials, to requesters and parents, and the schools should be doing so as soon as possible. All this bill is doing is setting up parameters and guidelines that both schools and parents and community members can rely upon when making these records requests. Another thing is that state law already requires schools, as we've discussed, to file a list of textbooks adopted for necessary use with the school clerk. As such, this list already exists, and all schools would need to do is post the existing list on the website. One of the reasons our open records laws do not have a specific timeline for compliance is because requests can range in size and specificity, making it difficult to know how much time it will take to fulfill. This bill, on the other hand, only requires schools to respond within 14 days after receiving a request from a resident to inspect curriculum or instructional material being used in the school district. Knowing who can request this and what can be requested in this section if it becomes law will ensure that school districts can comply more quickly and not create any additional burdens on school districts. And finally, this bill says that this subsection may not be construed to require a school board to take any action that would constitute an infringement of copyright under the Federal Copyright Act. This ensures that districts are not potentially violating the Federal Copyright Act by providing copies of textbooks and the records. I'd like to end by noting that other states have similar laws. As of February of 2024, at least 11 other states of all different political persuasions, and most of our neighboring states, have enacted state law on curriculum transparency through the state legislature. AB 5 would provide parents and residents of a school district with the assurance that parents and residents in our neighboring states already have. In all, AB 5 would provide the structure necessary to effectuate the purposes of federal law and Wisconsin open records law in order to improve educational outcomes, shed light on what and how students are being taught, and build trust between schools and the surrounding community without creating additional unnecessary burdens on school districts. Thank you for your time, and I'm happy to answer any questions that you may have.
Okay, thank you. Representative Pennerman.
Thank you, Mr. Chairman. Thank you for your testimony and for being here today. You certainly hinted at it, and I might have mentioned a couple times, but just for the benefit of maybe those watching on Wisconsin Eye or those who are still confused, and maybe Ledge Council can chime in too, but is there any time limit in current statute for complying with an open records request or the right to inspect materials?
So right now, there isn't a designated time for schools or any other governmental authority, and Legislative Council can correct me if I'm wrong on that, but to comply with an open records request, because like I stated, they vary in size and specificity, and different authorities have different retention requirements. It just kind of varies, which is why we used the language that we did in the open records law. However, We are talking about a very specific subset of information, curriculum, and instructional materials in a school district, such that putting a time limit on how long school districts can respond to these requests would be appropriate. It also, as I mentioned earlier in my testimony, would alleviate the problem of parents having to wait months and months and months or paying thousands of dollars for information that they should already be able to access so that we can accomplish the purpose of our open records law and federal law of having an informed electorate.
Right. Thank you. And then one follow-up, if I may. I tried to get at this a little bit earlier, but current law says that the list of adopted books shall be filed with the school district clerk.
Correct.
I think that's fine, but it's not out there. It's not publicly available. Do you think it would increase our sunshine laws and increase transparency if the school board has to file the list of adopted textbooks on the website?
Absolutely, and it would do so without creating any additional burden on the school district. They already have to come up with this list. All they'd have to do is post it online. They're already updating their website on a regular basis, and they would be able to just post that. Right now, the way that the law is written, parents would have to file an open records request with the school clerk to get the list of textbooks, and as has already been discussed, it would just be the titles. So this law creates a right of inspection. They could go and actually look at the textbook and look at what it says.
Thank you.
Yeah.
Further questions? Representative Cruz.
I'm just trying to get a sense of how widespread this problem is. Do you have any data on specifically how many districts are refusing access to curricular materials to parents?
If I could follow up with a clarifying question, do you have like a time limit on that? Because we get inquiries multiple times every single week from a wide variety of school districts. And like I said, I don't think all these school districts are doing it for nefarious reasons. I think that they're busy, and that's understandable. But the way that parents are being treated in terms of getting this curriculum and this instructional material right now is just frankly unacceptable. It's taking too long, or they're being quoted too much money and being priced out of having additional information on what their child is being taught. And quite frankly, I think that there's some confusion about the PPRA and what's required for schools to produce in terms of instructional materials and curriculum already. They should be providing that at no cost to parents. If that answers your, it probably doesn't. I don't have exact data based on I'd have to get back to you with I'd need a time limit, and I could produce a list of names for you.
Yeah, that's a very good point. Maybe just a school calendar year, like how prolific is this problem?
Very prolific. I mean, I focus at Will on K through 12 education issues, I get multiple inquiries multiple times a week about open records from school districts.
I'm not saying your experiences, you're speaking to that. I'm just asking for data to support it.
I don't have an exact number, but I could definitely produce that for you if you're interested.
Thank you. That's what I'm asking for. Thank you.
Any other questions? Well, thank you.
Thank you.
Okay, next up is Scarlett Johnson from Moms for Liberty speaking in favor, and then on deck would be Laura Ackman.